Nigga kill over a bitch, but let a rat keep his wife.
Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Miller. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I?
Yes,
I need 2 copies of it. Actually, 3.
Your sign.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposed order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So, you've been subpoenaed in this case to appear before and give testimony in this particular matter. and state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness, they've identified you as a witness, they've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you've taken the fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice. He had to be sworn as a witness.
Raise your hand. You swear affirm testimony to everybody, get a quarter of the truth, the whole truth, nothing but the truth, self?
Yes.
You maybe see, you state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KennethCopeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please?
All right, sir.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity, under 24-5-507. This court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody. All right. State, do you have any other witnesses you plan on calling this afternoon?
No, Your Honor.
Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt, because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter said.
Casey, that's what we've heard.
No,
so
the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be
Y'all make sure y'all hit the like button, hit the subscribe button. I'll be back with another one. Appreciate you. No 2 days the same.